You work hard all week long, let's watch something you don't have to think a lot about. And see some folks who you might just catch in a courtroom soon.
This is 23 CR 004678F. Mr. Mohammed, charged with 1 count of criminal trespass. Pretrial.
24 total. Last arrest was on the 3rd of this month for trespass. You're on probation for trespass and damage to property, loitering and prowling. That's 21 CR 004698C. They gave him 12 months back in April. He had a failure to appear from this year, 2021 trespass, 2016 disorderly conduct conviction, 2012 and 13 probation, and a 2011 carrying deadly weapon at a gathering conviction. State.
Yes, and Your Honor, he was also convicted on 23 CR 004152G for criminal trespass on July 18th, 2023, which was about 11 days ago. And he was placed on suspended probation. As part of the suspension, he was to stay away from 750 Piedmont Avenue Northeast, where this incident happened 11 days later, and to stay away from the premises of Timothy Olive, which is what we're back again for 11 days later. So this offense happened on July 28th, 2023 at 4:45 a.m. at 750 Piedmont Avenue in Atlanta. Officers spoke with Timothy Olive, who stated that the defendant was sleeping on the porch of his residence, which is a private residence. Olive had previous encounters with him and stated the defendant was issued a verbal and a written warning prior to this. Officers then spoke to the defendant, who stated he was sleeping there because he had nowhere else to go and that he knew about the criminal trespass warrants and, well, at that point, convictions. We are showing that the defendant on both the 21 CR case and the 23 CR case, both of those involved Mr. Olive's residence. So we're at the third time, 10 days after he was released from the previous two cases. The case in 2021, he pled guilty on April 18th, 2023, then got picked up for that 23 CR 004152G case, where he was just released on July 18th, then picked up again 10 days later. So we've had 3 visits out to this residence, 3 criminal trespasses, 2 of them he's pled to, one of them he's currently on probation on, the other he's on suspended probation. But either way, all of them have the condition to stay away from this house and stay away from Mr. Olive. I am not sure at this point what is going on. The state is going to recommend a social worker, as well as potentially we can reach out to PAD to see if there's any services that can be given here, because I think something else is happening and I don't know what that is. The state, there is a preset $1,000 surety bond. At this point, he's violated his probation, so we'd ask that it remain as set, that he stay away from this address, 750 Piedmont Avenue Northeast, have no further contact with Timothy Olive, and we again are requesting a social worker. And it does not look like Mr. Olive is here in court.
Okay. All right, Ms. Melnick.
Yes, Your Honor. My client has significant ties to the community. He actually lives in Ellenwood, Georgia. He was asleep on the premises. He knows that he is not supposed to be there. I said, I don't know what word you don't understand, but we can't go back there. And he knows it. He's going to go back to Ellenwood, where he resides with his family. So we would ask, since he is unemployed, it would be tantamount to no bond. And we are asking for $1,000 signature bond.
All right, I'm going to leave the bond set at the $1,000 surety bond. I'm going to order stay away from 750 Piedmont Avenue Southeast. I'm going to order stay away, or I'm sorry, no further contact with Mr. Timothy Olive. And see if the social worker can get to him. And no drugs, alcohol, weapons, or guns while on bond.
And Your Honor, with Ms. Melnick's consent, I would like to reach out to PAD and HC to see
I
if
am the
they're-
public, he is not qualified for a mental health court. We're not going to just push everyone over there. I'm the public defender that's assigned to that court.
Well, I've been also asking Ms. Corley for any references for services, not just to put them in the court.
Okay.
So we're also
no mental health-
utilizing this to see if there's any services that can be offered. But if you would rather he not have those services, I completely understand.
Not to the mental health court. He just doesn't qualify.
And what about social worker can,
Yeah, I have no objection to social worker of PAD.
okay, okay. Thank you, Deputy Falk.
Position 14, Mr. Jarvis.
This is 23 CR 004682A, Jarvis Parish, charged with 1 count of simple assault, family violence, pretrial.
This is 10th arrest, 2017 trespass. 2017, 2012, 2011 possession of marijuana conviction. Yeah, the 08 battery DVD. It was dismissed though. That's it.
State?
Yes, Your Honor. This incident happened July 27th, 2023 at 1155 La Vista Road, Northeast in Atlanta. Officers, okay, do we have, before I get started with this case, because I've fallen for this once before, who's handling this one? Because I didn't know if Ms. McLeod is handling it before we get started. Okay, great. I didn't want to get started and then find out that the lawyer who's handling it is
right.
available. All right. So officer spoke with Miss Jacqueline Taylor at that address. Miss Taylor said she was in her room. The defendant entered. He was upset about a court case. She tried to push him out of the room. The verbal argument continued in the kitchen, and that he began swinging at her, but made no contact with her. The defendant then pushed a glass off a counter, and Miss Taylor said she cut her hand when she tried to catch the cup. Both of them are roommates. I will point out that Miss Taylor was released on a $2,000 signature bond through pretrial, was given no further contact with Mr. Parish and a stay away from the La Vista address, which is Mr. Parish's address, not Miss Taylor's. They are roommates, but Mr. Parish actually owns or rents that location. To that end, the state is going to recommend a $3,000 signature bond through pretrial services for Mr. Parish. No further contact with Miss Taylor, 1 day anger awareness, and no alcohol, drugs, or weapons. We are not asking for a stay away since Miss Taylor has already been ordered to stay away, and that will put them in essentially the same position.
All right.
Ms. Falk, I'm sorry, I didn't hear what your bond recommendation was.
$3,000 signature bond through pretrial.
Okay, we are okay with that.
Okay. All right, I will order the $3,000 signature bond through pretrial per judge. I'm going to order the 1 day anger awareness course. I'm going to order a stay away. Oh, I'm sorry, no stay away.
Yeah.
Right, no stay away.
No, and she's staying away.
Right. And
That's
I'm going to order just the no further contact then with Jacqueline Taylor.
That would be fine. Yeah.
And no drugs, alcohol, weapons, or guns while on bond. Anything else, counsel?
Nothing further, Your Honor.
Nothing
All
from
right.
the state.
What was that bond?
That was $3,000 SOB pretrial per judge. All right, so I have him here, 23 CR 004525G, is that correct?
Yes,
All right, and it's Ramon Stewart,
yes.
and I won't read the charges to confuse us, so tell me what you have, State.
Okay, so he has 5 charges that are pending. The first count is battery. The second count is simple battery. The third count is cruelty to children. The fourth count is cruelty to children. And then the fifth count is simple battery.
Okay.
This was a felony transfer to our office, so there currently is not a bond set, and I believe defense is requesting a bond hearing.
That's correct, Judge.
And I have the offense date for all is April 21st, 2023.
Yes.
Okay, do we have pretrial on with the history, or will State give me the history?
Nope, I
There we
have
go.
it.
Oh,
Yep, I
good
have
morning,
it.
how are you?
Hey, good. How are you?
Good.
Looks like Mr. Stewart, he has 7 arrest cycles beginning in 2004. It appears the clarification of the charges on the calendar. So his last arrest was April 22nd, 2023, and it was for the 2 counts of aggravated assault and the cruelty to children. That's what's listed on the GCIC. Let's see. It appears he doesn't have any other felony convictions. Yep, no felony convictions. He did have a misdemeanor willful obstruction that he received first offender treatment on. That was March of 2008, and the case was sealed March of 2009 in Newton County. See, and he does have 2 arrest cycles out of Louisiana. His last arrest was October 2013 for disturbing the peace, public intoxication, and resisting an officer. No disposition is listed for that case, Your Honor. Nothing to add.
All right.
Hey, Your Honor, in this case, law enforcement was dispatched at 1974 County Line Road. They spoke to the victim, Ms. Hall, who advised that her boyfriend came home intoxicated. He accused her of cheating, at which point he became irate. He did grab Ms. Hall and throw her through a wall, and then he began to choke her. Ms. Hall's 4 children were present. She had a 14-year-old and a 13-year-old that attempted to intervene. Her oldest son, the 14-year-old, who I will refer to as A. Miller, attempted to separate Mr. Stewart off of his mother as Mr. Stewart was choking his mother. Mr. Stewart then punched the juvenile child, Mr. Miller, in the face, and then began to choke Mr. Miller. At that time, her other son and the victim, Ms. Hall, collectively was able to push Mr. Stewart out of the home. But then again, he grabbed her juvenile son, Mr. A. Miller, and body slammed him. Upon arrival, the law enforcement officer was able to observe the hole in the wall in the living room. There was blood on Mrs. Hall's shirt, and he did observe a ripped shirt on the juvenile, Mr. A. Miller. For the first count of battery, the state is requesting a $3,000 surety. For count 2, the simple battery, we're requesting a $2,000 surety. For counts 3 and 4, we're requesting a $1,500 surety. And for counts 5, which is another simple battery, we're requesting a $2,000 surety. If my math is correct, I believe that is a $10,000 good bond in total. Nothing further at this time.
All right. Mr. Finley?
Yes, Judge. Mr. Stewart is 38 years old. He does have 2 children. That being said, with his current girlfriend, she does have 8 kids, which he presumes and he supports, and he's the main financial supporter of them. He's been with his girlfriend. They've been friends for 15 years. But like I said, they've been together, living together, and he's been financially supporting her and her family as well. As we heard, Judge, he does not have any violent convictions. He does have community ties, Your Honor. He's been in Georgia for 33 years. He has friends, family here. And I've stressed to him the importance of returning to court. He assured me that he would. Also, the stay away is not going to be an issue, as he does have somewhere to stay. He'll be staying with his mom, Judge. And while I do recognize the seriousness of the charges, and I did hear the incident report, it is exactly that. It's an incident report, and he is presumed innocent on all of these charges, Judge. So I would ask for a bond to be set, totaling $2,500 for the entirety of these charges.
Your Honor, just to clarify, he does have a previous battery, family violence, first offense out of Douglas County. There's just no disposition listed for that, and that was May of 2014. And he has a terroristic threat out of Douglas County, a felony terroristic threats and acts, that it looks like it says not guilty, acquitted, December of 2015. And he has an armed robbery arrest in Douglas County from October 2014. Also, it was dead docketed August of 2015.
Okay, so you're adding, that's a lot of history out of Douglas. Okay.
And Judge, I would just reemphasize again, while I did hear each of those, I did not hear the word conviction on any of those. So while I do appreciate that being read, it's a very different being charged with something and being convicted of something. So I stand where I say you could have a surety bond set for all of these at 2,500.
Of course, the state's position feels as though a $2,500 surety bond, considering the circumstances that this involved a mother and her two juvenile sons. The one son that was assaulted, he was 14. The officer observed a hole in the wall. He observed blood on the mother's shirt. The 14-year-old had a ripped shirt. This started out as an aggravated assault. He strangled the mother and then strangled her 14-year-old. So we feel as though the $10,000 surety bond in total is more than reasonable. And her other two, there was 4 children that was present, and there was also a 6 and a 7-year-old that was present as well during this incident.
Okay. Do I need to sound for the victim? I'm assuming I don't see anybody with that name. Is the victim on the line at all? Is it Hall? H-U-L-L?
H-A-L-L, Miss Hall.
Oh, Hall. Is there a Miss Hall on the line at all? Okay. All right, I'm going to rule that and order the $10,000 surety bond, $3,000 on the battery, $2,000 on the simple battery, $1,500 on each of the 2 cruelty charges, and $2,000 on the simple battery for a total of $10,000 surety bond. There will be a stay away from 1974 County Line Road. No further contact with Ms. Hall. No further contact with the minor children of Ms. Hall, including victim A. Miller. And I don't know the name of the other one who's 13.
It's E. Miller.
E. Miller, okay. And no drugs, alcohol, or weapons or guns while on bond. And that's all I'll order at this time.
And Judge, could you please just repeat one more time the cruelty to children? What was that charge?
Each of those, the 2nd degree and the 3rd degree, 1,500 surety on each of those, 1,500 surety.
Understood. Thank you.
All right, thank you.
Position 37.
Judge, can you hold on a minute?